Alright, in this video we're going to continue with the commercial crime matrix. Let me log in here. And if you remember before, we started out with the challenge to the constitutionality of a statute. And that was, we used a notary presentment and challenged the constitutionality of the statute, saying that the statute violated the Constitution's prohibition against slavery because it's being forced on a man, making the man a surety, also known as a slave, which is against the ecclesiastical biblical law. And it violates the man's right. It violates his right to not enter into a contract freely with his intent and willingly and knowingly, and it violates his right because a forced contract is slavery, and all constitutions prohibit slavery. So we brought out those things and the fact that there was no injured party and that the accuser didn't have proper standing. We brought all of those things out and we related them directly to constitutional provisions because that is the state's obligation to the people, and we presented in such a way that we expected that we would not get a response. And again, the whole purpose of this commercial crime matrix is to shut down the quasi-criminal proceedings by any means necessary. This time we're going to go ahead on down here and we're going to go to judicial notice of status. And where would we use this? This would kind of be something that we would want to record in the record if they continue to force us into the jurisdiction. You know, if we're firing attorneys on the record, challenging the constitutionality of the statute, challenging the jurisdiction, challenging subject matter and in personam jurisdiction, and we're doing all that and we find ourselves being forced in, then we want to then this is just a part of the strategy, which is judicial notice of status. Because, well, let's Google real quick what judicial notice is. So here's Wikipedia. Okay, judicial notice is a rule in law of evidence that allows a fact to be introduced into evidence if the truth of the fact is so notorious or well known or so authoritatively attested that it cannot reasonably be doubted. So basically, the reason I showed you that is because what I'm trying to express to you is that by filing an affidavit and taking judicial notice is a way that you can introduce the necessary facts that you're going to need to deal with this quasi-criminal matter. Now again, we don't want to participate in this, but if we're being forced to do so, this is a tool that we're going to use at our disposal. So let's kind of go into, first let's go into, let's read the judicial notice. First, I want you to Google though. Google, where's this PDF I had for you guys? And you'll find these PDFs at the bottom of this. Here it is. And this is California Evidence Code section 450-460. Remember, the judicial notice would make, now this is the important thing to note. One of the things that I've learned from someone who taught me, that the lower courts, which are the trial courts, they're not really dealing with the law. Their determining factor is the facts. They're making rulings based on the facts. So this first level of court, the facts is what's going to be important. So judicial notice is a way that we can introduce the facts that's relevant to any defense or relevant to any cross claim that we're going to be making for the violations and the crimes that's being committed against us. The judicial notice is our way to introduce those facts that's going to support the claim that we're making. So that's what we have to think of. We have to be thinking in advance, because your battle, again, has to already be won before we get to the courtroom. That's, again, with the purpose of this commercial crime matrix to shut down these quasi-criminal proceedings against statutory persons by any means necessary. So this is under the California evidence code. You have to look in your state to find the relevant codes that deal with judicial notice, and I'm just going to go over the highlighted parts, because these are the parts that I want you to think about when we're trying to introduce our affidavit of judicial notice in the record to get certain things, certain facts on the record.
Judicial notice may not be taken of any matter unless authorized or required by law. Judicial notice shall be taken of the following: the decisional, constitutional, and public statutory law of this state and of the United States, and the provisions of any charter described in Section 3, 4, or 5 of Article 11 of the California Constitution. And when you go into Article 3, 4, and 5, they're talking about the charters, the charters of municipal governments, of cities and counties. They're talking about you can take judicial notice of those charters and other governing documents. Go back in there and check it out, because you're looking for anything that is any record or any type of record that will support either your claims or your defenses, and you want them judicially noticed. That's why we're going through the document. Okay, any matter made a subject of judicial notice by Section 11343.6, 11344.6, or 1876 of the Government Code, section whatever. I looked these up just because they were important. Usually when I see something like this is the type of thing that when people are reading, that they will easily skip over and say, oh, I'll come back to it later. And that's not true research. You know, if you're doing that, you have to go in and go look these things up. I put notes over here what they are. This one deals with repudial and rescission and giving notice to the Secretary of State. So you might want to look at this if you're considering doing a TILA rescission. It might require that you get the document authenticated, but you may, look at this type of thing. Look at your rules of judicial notice, because this is going to tell you how to get all those administrative things or those certificates of service to prove certain facts into the record. Right? That's why we're reading this. 11344.6, let's see. That deals with, that's the one that deals with repudiation and rescission. And then the other one that I just named, well, I don't know. Go look him up. Judicial notice shall be taken to the board, department rules. Others is like the board, department rules, regulations. But when you go through your judicial notice, you're pretty much going to find out that anything, agency rulings can be, judicial notice can be taken of that. Records of government agencies, almost anything that you can extract from the Freedom of Information Act, all that information, all government information in one way or another can be added to the facts, and judicial notice can be taken of it. Here's another interesting one I highlighted here. This should be very powerful. Think about the different ways that you can use this to your advantage. These are things that mandatory judicial notice. I'm not saying that necessarily means that the court is going to rule in favor, but these are mandatory. These are things that they're mandatorily supposed to take judicial notice of. One says, the true significance of all English words and phrases and of all legal expressions. So you definitely have to take this into consideration when they're trying to charge the person. One thing they don't want is you to be on there exposing the fraud and removing the veil of confusion right there. I think they would much rather change the circumstances to get you out of there. So consider the things that you can do when they have to take mandatory judicial notice of the true signification of all English words and phrases and all legal expressions. Words such as you, that mean the second person. right? Because there's a third person and second persons, and all of these different people have different positions on the estate. That's a whole nother topic. Facts and propositions of generalized knowledge that are so universally known that they cannot reasonably be the subject of dispute. This basically right here tells me that anything that you can think of can be judicially noticed. Because one thing that I've learned about facts, because I sometimes pay attention to the difference between facts and truth and verification and all that type of thing, and one thing I know about facts is they're completely independent of truth. Facts can be any damn thing that anybody alleges. So for them to say that you can take judicial notice of facts that are universally known that cannot reasonably be the subject of dispute tells me that basically that subjective information can be judicially noticed. And if you think about it, and analyze what you can do with that properly, you can judicial notice anything via that you can establish as fact. So again, you want to start looking at administrative procedure. Your administrative procedures, once perfected, can be included with the facts to support and defend your position or whatever you're trying to do under judicial notice. So this is why it does become important when we talk about things like your affidavit of life. Why it's important, your common law copyright, all these things to have previously been done, because these are basically acts of state that have the full faith and credit of the United States. These are intangibles that have to be that may be judicially noticed. And there's a lot going on with what we're establishing here, right? Again, the end result is to kill these quasi-criminal proceedings by any means necessary. We're bringing up a lot of things that we know they really don't want to deal with. This is an important one. Other things, it says here, I'm at 452, judicial notice may be taken of the following matters to the extent that they are not embraced within section 451. Here, this right here is basically telling you case law. The decisional, constitutional, and statutory law of the states of any state of the United States, and the resolutions and private acts of the Congress of the United States and of the legislator of this state, regulations by the legislative enactments issued by or under the authority of the United States or any public entity in the United States, official acts. Official act is almost anything that the Secretary of State affixes its authentication. As if you do an act, if you do an act, right, in trust or in sovereign, as a sovereign, whatever capacity you do that act in, if it becomes an official act by the acknowledgement and the authentication on the Secretary of State, whether authentication or apostille, it may be an acknowledgement of a foreign act. It may be judicial notice may be taken of that. Records of any court. Your private administrative proceeding is a court. Any court of record of the United States. Your private administrative proceeding that you do by notary presentment and registered mail is a court of record. It's a court of record. So hey, this is the authority for judicial notice. Go read over it, and just start expanding your mind. Start thinking outside the box. Now let's look at. Now I'm going to read over this document real quick, and then we're just going to close out of here. Actually, it's under the commercial crime matrix down here, judicial notice. So this is the one that I used in this series. Where is it at? Which number is it? Okay, here it is. Judicial notice. Okay. And again, when you modify this and make it personal, which you absolutely must make it personal, I cannot express how important it is that this is the style that I use. You probably just want to go in accordance with the rules of procedure if you do something like this. But you just don't just lift this document and paste it. You're going to prejudice everything that we're doing. You might end up injuring and harming yourself. And this is leg. You still have to research and put something together. This is just to help you and get you thinking. Some of this you should be swiping out because it doesn't apply to you, or you just don't feel good about it, and you should be adding to it. It should not be recognizable, and it's not going to work for you. And I hope it doesn't work for you if you just try to copy and paste this and it's state. This is a research tool. Coincidentally, a lot of these I've used for myself. So let's read. So that's what judicial notice is. Now, one of the things about judicial notice, if you go back and think about what we just read, these things have to already be a matter of record, right? So most of the things that I'm gonna take judicial notice of in this affidavit, or petition the court to take judicial notice of, or demand the court to take judicial notice, or request the court, or motion the court, whatever. These things, many of them are already going to be a matter of record. Consequently, I like to order certified records from the Library of Congress, because if you go read through that, some of it talks about certifications, things that can be judicially noticed. So if you look up here, you'll see Resolution 75. Moorish Americans may be interested in this. This is the Sundry Free Moors Act of 1933. And this is from the Legislative Journal, House 5759. This was in Philadelphia, the old capital. And it was basically legislation supporting the use of the titles El, Day, Ali, Bey, etc., which is a very powerful position to have the court to have to acknowledge your title, because that ties you back in, and rights are extended to those who have a cognizable nationality, which basically means being tied into one of the families. Anyways, you got that. The Declaration of Rights of Indigenous People, that's an international law, human rights instrument under Executive Order 13107. The United States has to implement universal, I think it's 13107, yeah. They have to implement human rights instruments, and supposedly, President Obama endorsed this. Now if you go to Department of the State website, they say he reneged. Did he really renege? I don't even really know. It doesn't even matter. I've seen no proof of it. I guess you can, say he reneged it. I don't know, but I include it as a reference, because all of these things are official, and they're, all of these things, when you look into the judicial notice, they are the type of circumstances that it says they're supposed to mandatorily take judicial notice of. So it's very powerful when you have certified records, right? So when you learn about these things, such as, say for example, the affidavit of Todd Walker, why don't you see about using FOIA requests, or just doing some research, contacting those courts and asking for a certified true copy of that record, so that you can have it if you have to use it, and take and have the court take judicial notice of certain things. I've also have judicial notice of here of Pope Francis' apostolic letter dated July 11, 2015, where he removed the immunity from everyone under the Vatican rule, which is all of the judges basically, and magistrates, and this whole, many of the officers, according to my research. And if not, we're going to take judicial notice of that fact anyway, because it deals with almost all public officers. You may include a registration of the certificate of live birth if you've done any of the Rule 220 type of stuff, or any other certain registrations that put some type of title or claim on that security. You might want judicial notice of that. Now, of course, this is not, if somebody reads this, they're going to be like, hell no, this is not going to go in there, right? Goal is, by all means necessary, shutting this crap down. If you've done a copyright, which, I've done a copyright, many of the premium members have done a copyright. I've always said it's one of the most important things that you should do. If you don't understand it, maybe you want to get a coaching and consulting session, and let's talk about it. I'll tell you my experience and what I've done. But I want to take judicial notice of that common law copyright and that $1 million violation that's there, because this is also a public record that's going to be that you can also get authenticated as an active state, also making it mandatorily judicial notice. So pay attention to that. When you read the things that can be judicially noticed, go start reading about authentication and apostille, and compare the two back and forth and make the connection. All right. So let's read through this. I hope I can get through all of it. If not, you can read the template for yourself. To all elected officials, United States Republic officials and public servants of federal, state, city, and municipal governments, personal and corporate entities concerning the Constitution and blah, blah, blah. That's the introduction. And then I go into my affidavit, I, Crimin-AL, Tex Lee. It says issue of God law. I got to change that. That's gonna be a bit different. And then I'm gonna say in full life, because I want to know that if you're dealing with the living man, there's no civil liber mortuus. There's not dead in the eyes of the law. I'm in full life, domiciling on the land, the heir and the beneficiary to the estate, being of full age of majority and of sound mind and competent, does affirm and hereby gives notice of the facts. I'm giving them notice of the facts by affidavit. So this whole thing is an affidavit to be rebutted within itself, but I'm also going to make sure that each line of fact that I'm alleging also has a public record associated with it, such as the registration of the affidavit of beneficial ownership regarding the certificate number whatever for the Tex Lee Masson was recorded in ABC County Recorder's Office book whatever, etc., etc. If I did that proceeding and I got that instrument recorded, I'm going to take judicial notice of that, and I'm going to put the recording information so the court can take judicial notice that this is a thing that has already been done, such as Part 2. Defiant is of the family Crimin-AL, of whom are American Moors, tribe of Judah, of the lost sheep of the house of Israel, who are descendants of the Moors of African origin and native to America, as acknowledged in Resolution 75, incorporated by reference A. Maybe you should go and rewrite that. Again, this is a draft, and this is why we're kind of just discussing this, but because maybe this seems too much like I'm suggesting Resolution 75 talks about the lost sheep, and it doesn't. It just talks about our ancient, that it talks about our right to use our titles of nobility, which were always a part of it's a part of our lineage, a part of our heritage, a part of who we are. So, but Resolution 75, you work that out. All judicial officers and attorneys of the United States have obligations under the Declaration of Rights of Indigenous People, incorporated by reference B, and the authority of Executive Order 311234. Let's check that. That doesn't look like the right executive order number. I think I quoted the right one earlier, but we're going to check that out. But all you got to do is do Executive Order Human Rights Instruments. And I'm going to go correct this when I finish this video. So by the time you're downloading the document, that'll be the right number. But see, notice these are things that are already done. These are public records. They already exist. I'm supporting everything that I'm asking them to take judicial notice of. Right? Those holding federal or state public office, county or municipal office under the legislative, executive, or judicial branch, including judges, prosecutors, law enforcement department employees, officers of the court, and etc., before entering into the public office are required by the U.S. Constitution and statutory law to take an oath, and that oath is under 5 U.S.C. subsection 3331, oath of office. You can follow this little footnote reference down here. I'm taking judicial notice of their oath. Why am I doing this? Because I'm snapping them into the constitutional jurisdiction that I'm entitled to. Because if you don't dictate and change the jurisdiction, they're just going to try to, pillage and plunder your estate under the laws of intestate estates. Those who die without a will, those whose estates have been abandoned, and those who are minors, those who are incapable of administering their own affairs. All right, let's see. So we took judicial notice of their oaths of office. By virtue of that oath and by authority of the U.S. Constitutional Article 6, Section 2, the court must acknowledge the Treaty of Peace as the supreme law, incorporated by reference C. So then I also include a certified copy of the Treaty of Peace and Friendship And you can do this with any treaty that you're going to bring in. Get a certified true copy for the Library of Congress or some other world depository. This is where you're going to have to get on Google and do your research and find out where these places are. Okay? But all these official certified documents, you can take judicial notice of them. So think about what you can do with House Joint Resolution 192 and all these different type of things in your proceedings. You got to be willing to think out the box and remain in the truth. Public officials are considered a foreign agent. I put the citation for that in there. And has a further loss of nationality by native-born or naturalized citizen, voluntary action, burden of proof, and presumptions. In order to hold public office, the candidate must file a true and complete registration statement with the state attorney general as a foreign principal. I don't know if that read right, but basically I'm establishing the fact that they are foreign agents. I have accepted for value the oaths of all officers, creating a binding and enforceable security agreement in their bond per UCC 9 section 203. So I basically am also establishing for the record that I've accepted for judicial notice. The reason is that now this you wouldn't even have this in here unless you've done something relative to have that statement in there. Why am I saying that? Because if you're going to be using this template, if you don't understand something and it doesn't apply to your situation, take it out. It's not going to work for you. It's going to only make you look incompetent, right? The reason why I kind of suggested putting this in here in my regard, because if I were to be discharging this obligation some type of way, I would want the fact already established that I've accepted their oath for office, because I'm binding them into that agreement and holding them accountable as fiduciaries to make sure that they've done what they're supposed to do. That's just me binding that contract in there. But I say that because some people don't even understand what that is, and they're just going to copy and paste and put that in there. Please don't do that. They've already mentioned our website negatively before, and in writings from United States District Court, and maybe at some point when I have the resources, I'll be able to go deal with these type of slanderous remarks. But nonetheless, help us out. Use these as a research tool, build upon them, and show me what you did that's better than the template that I gave you. Okay. And here's a key one. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. Marbury versus Madison. This is a Supreme Court case. If you remember, they have to take judicial notice of determinations from Supreme Courts of the United States. So that's basically telling you they cannot war against the United States and at the same time support it. With this thing right here, you need to start reading and understanding the Trading with the Enemy Act, and read the Trading with the Enemy Act, and then go back and read this again. No state legislator, executive, or judicial officer can war against the Constitution. That's why we keep talking about the Constitution. They cannot war against the Constitution without violating his oath and undertaking to support it. That's Supreme Court case law that they have to take judicial notice for. So what does that mean? Now let's start thinking about the very first step that we did with the Rule 5.1 constitutional challenge to a statute. Why I was saying it was kind of important to present this with notary presentment, demanding that the Attorney General respond, because your rights are at stake, and you may want to start again pecking and contacting and pinging risk management at this point, because there's a constitutional guarantee with these municipal agencies, and that you are a beneficiary of, and those rights are guaranteed. So once you have established the fact of record by assent and tacit acquiescence and commercial default that their quasi false claim is not constitutional, right? And then now you also have the Supreme Court saying that a judicial officer cannot war against the Constitution without violating its oath and undertaking to support it. And we already know that these are foreign agents, and in order to do their business here for their foreign agencies and companies, they have to take that oath to support and defend the Constitution, right? So when they're in breach of that and they're violating that, And now we know if we're looking at someone who's involved in the slave trade, or they're a pirate and they are committing treason. Because why would you continue to pursue a quasi-criminal complaint against a person when there's no injured party and the accuser lacks proper standing, and it's been proven by default that it's not constitutional? Why would you keep pursuing unless you were doing it because you were escrowing funds from the estate, using your position to create money, or using your position for profit, your elected seat of government for profit? And all of that is a violation of the Trading with the Enemy Act. It's a violation of the Libra Code. It's a violation of the Constitution. And this judicial notice and the established facts that are in here sets things up for the criminal cross complaint, where you're actually making an accusation, where I will be making an accusation. Let me speak about what I'm doing. These are templates that I've used or am using or preparing for myself. And that's what this is leading to. So that's why getting judicial notice of these facts are important. This is an important one. All courts in the United States are operating under the Trading with the Enemy Act of 1917, etc., etc. Then you can read out all of these citations of authority. Again, we don't really want to have to deal with this stuff. The reason why I put so much energy, prayer, and intensity in this document is because this is to help free us from this commercial slave system. We want to shut these processes down by any means necessary. Now, notice regarding immunity and liability. And I really think that I encourage people, I'll try to put the links at the bottom of this video about the pontiff's letter. Not saying that he's our authority, but he's definitely the authority of these municipal officers and agencies about the removal of their immunity. Based on my experience and other people's recent experience with these courts, I'm thinking we're starting to see a different type of behavior, and this has a lot to do with it. And a lot has to do with it of the true nature of who we are, the true nature of who so-called black and African Americans really are. A lot of it has to do with that, but a lot of it just has to do with the time. And so let's so you can read. I'm not going to read the rest of this. Well, let's see. All this talks about any foreign sovereigns are liable for damages while doing business in the United States. This is the judges, clerks, etc. that operate on behalf of the de facto foreign fiction government. Officials are liable for damages that they commit while doing business in the country. And that comes out of Title 28 of the United States Code. Things that they have to take judicial notice of. So this goes back with what I was telling you earlier. Foreign agents escrowing funds from the estate, administering the bankruptcy, affording constitutional rights to the heirs because they have to. Right? That's just kind of a way to think about it. I also gave judicial notice that I did a discharge of the matter, and an unrebutted affidavit, etc., etc. And get your acknowledgement down here. And this is what you would do. This is a part of your strategy in the commercial crime matrix to shut down the proceedings by any means necessary. Hotep, blessings and greetings. Islam, peace and love, my Hebrew Israelite brothers. Give thanks. I'm out.